If you're being charged in Massachusetts with serious felony charges, chances are you're going to end up in Superior Court. The way that it happens is that a prosecutor will present your case to a grand jury, and if the grand jury votes that there's enough evidence for probable cause for you to be indicted or charged, then they'll return a true bill. And if they return a true bill, then you'll be indicted, then you'll be formally charged in Superior Court, arraigned, and then the whole process would start in Superior Court, just like any other criminal case. Now, a grand jury is a secret proceeding, so a prosecutor can present evidence. They present evidence that is usually favorable to them, although they're supposed to be fair. They present police officers. Sometimes they present other civilian witnesses. And this grand jury is conducted with a group of 23 people, although there has to be at least a minimum of 13 people in order for them to return an indictment. So if people are out sick, whatever, it can be at least 13 people. But generally, 23 people are listening to the evidence, they're observing witnesses, they're taking notes. They can even ask questions after the prosecutor asks questions of each witness. And at the end of that, if, again, the grand jury comes back and they say, yes, there's probable cause, they vote on it, or a true bill is returned, and then you're indicted and formally will be charged in Superior Court. At the grand jury hearing, you as a defendant have no say. You don't have any right to be present, although probably your lawyer would tell you not to do so, even if given the opportunity. But you have no right to be present, and you only find out about it if either the prosecutor tells your defense attorney they're going to indict you, or sometimes you don't know about it until after you've been indicted. If you're subpoenaed to a grand jury, chances are you're probably not the target of that. You're probably not the person that's getting indicted, but you might still have criminal liability. So it's important to check with a defense attorney. You might want to hire one to consult with you to determine whether or not you have a Fifth Amendment right, for example, not to testify. And if you do retain an attorney to go with you to the grand jury, you have a right to have your own attorney in the room with you. I've done that before. And your attorney would be sitting right next to you. You even have a right to consult with your attorney privately. You can whisper and you can ask questions. You can even ask for a break. So if you do bring an attorney, your attorney has a right to be with you, but the attorney doesn't have a right to say much of anything. The attorney can't object. The attorney can't tell the grand jury anything or present evidence, but it can still be helpful because if you get asked a question or if you start going down a path and you're not sure it's good for you, or maybe you're entering into territory where you would have a Fifth Amendment right, where previously you didn't think there realistically was one, you can confer with your attorney and your attorney can provide you with legal advice and again be in the room with you. So you might have some comfort because you've got somebody that's on your side next to you in the face of a prosecutor and a room full of grand jurors.